in the matter of petitioner Paul Nurswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
All right, guys, welcome back. Today we're picking up the Lindsay Dineski saga again, and this time the plot swerved hard. Part 4 wasn't even supposed to look like this, but Lindsay recently got arrested for resisting when an officer ordered her out of the vehicle. That's a terrible move on any day, but it's even worse when there's an active warrant hanging over your head. I've already requested the body cam footage, so while that's processing, let's watch her do what she does best. Turn a courtroom into her personal stage.
Dineski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, the law says. The law says if I do not have proper service, it's an invalid warrant.
She's technically right that service matters, but her argument collapses once you look at what she did. Lindsay moved and never updated the court with a new address, and that detail changes everything. Courts don't play hide and seek. They rely on the last address you provided in filings. If you leave and don't update, you don't get to pretend you're unreachable and call the whole case invalid. The system isn't obligated to chase you across states because you decided paperwork doesn't apply to you.
Okay, Miss.
Me into trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nurswick's mail? You were interfering with his mail, Ms. Nurswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that appears.
Do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18-241 and 242, and I'm going to be asking for the death penalty for you.
They step away for a minute to confirm the service details, and watch this closely. Lindsay doesn't reset, doesn't calm down, doesn't even pause. The judge returns and she's already mid-sprint, like the break never happened. This is one of those people who hears, "Hold on," and takes it as, "Talk louder." And that's exactly what she does.
This is also a bill of pain and penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Is like
Ms. Danelski, I'm gonna put you in the breakout room with Ms.
This is a
Williams,
violation
who
of
is
my
your,
Fifth Amendment. This is a violation of my
Please
Sixth
don't put you
Amendment.
on the
This is
breakout.
a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Oh, that's adorable. Now she's handing out death penalties like party favors. She throws that phrase around like it's a magic spell that makes everyone freeze in fear. She's threatened me with it before too, and at this point it's basically her signature move. If you get one, congratulations. You've been officially added to the Lindsay Daysky Fantasy Court. Up next, they leave her alone on the call, and she starts arguing with the
Okay,
air.
we don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And I need to
Deputy,
see
did you
your
hear
own-
me? Officer?
Your Honor, I do have a 2:00.
I need-
Did you want me to come back? I have a 2:00 in
I
judgment.
don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about
Prosecutor.
2:30?
I want to say something. You guys are, I've
Miss
talked about
Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was
I
not
got
even
you.
notified of this court. I was not even given notice of this court date, and I've
Yeah,
been here
so-
5 days.
Mr. Nash,
What,
please
let's say
be quiet.
1:45. I don't have a
You
prosecutor.
need to
I
be
can't
quiet.
do
This
anything.
is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay,
right, we'll
I'll be
see y'all
back at
back at
1:45.
1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30 or are
I'm
we
waiting
looking
on the
at
prosecutor.
2:30?
I can't,
Well, it
like,
has
the
to go,
record is
Your Honor,
going
I have
now.
a 2:00.
I can't
I
call it.
don't
So,
need a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank you.
Sounds good.
You just ignore my questions.
Well, then stop asking dumbass questions. Now, a few hours later, the prosecutor arrives and the hearing continues.
I do believe arraignments can take place without the prosecutor's office, but
I kind of thought
Might be
so. I
tricky.
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
I've been, this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-borne arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This is
progress.
case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office?
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, House Counsel on behalf of
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And
Certainly.
I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation, which 2.516.
No, I'm sorry,
rule of
2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because
Lindsay
it's
genuinely cannot stop talking. Not to listen, not to think, not to let a single sentence land from anyone else. The judge steps out for a moment, and even then she keeps going like the court is still actively debating her. And when the judge returns, it's not to resolve anything, it's to delay the hearing because they're waiting on a prosecutor. The wild part is that this could have been quick, but Lindsay makes quick impossible.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also.
Dineski,
the reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say I was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates, I would ask that the arraignment for the bench warrant continue. And I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se. And I believe it would be appropriate to.
I'm proceeding sui juris in persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do not consent to an attorney.
Ms. Janeski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you
Your
understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arraignment.
Miss. Procedurally, there are things we have to do, Mr.
No, not if my rights are violated.
Normally, arraignments like this don't need the prosecutor physically present, but Lindsay is the exception to every normal rule. She turns basic procedure into a full-length argument, then tries to win that argument by talking over everyone. So yeah, today needed extra staffing. She doesn't just complicate things. She forces the court to build the day around her interruption.
Procedure does not cut my rights.
Mr. Tudge, do you have a response to that?
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent, or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on the respondent to do so.
All right.
No, it would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, she doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this. Ms. Dineski, you've been advised of your right to have counsel. Is that correct?
No, I have a right to assistance of counsel.
All right.
Okay.
Do you want assistance of counsel, Ms.
She can
Dineski?
assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now, but I do appreciate her very much.
So you asked for the assistance of assistant attorney, Ms. Fort Williams.
No, I didn't ask for it. She gave it to me, and I accepted her opinion, but I don't, the law does not agree that I can't ask for this to be dismissed in an arraignment, because Lufkin v.
All right,
McVicker
so
says
your
that.
request for dismissal is denied.
Why?
Because a court doesn't just dismiss a case because a petulant Karen demands them to do so. That's why.
And Your Honor, I would ask.
And you have to, I'm also.
Hold on, I
asserting
need to
my
hear
right.
from Ms. Fort
It's
Williams.
my turn to speak. When do I get to speak?
Hold on.
Your Honor,
Ms.
I asked
Fort
that a
Williams.
plea of not guilty be entered, and I'm asking that she be given personal bond. She is a resident of Detroit, Your Honor, and she's been incarcerated since the 13th. And I'm asking that she be released on her personal recognizance. Thank you.
Thank you. Because I'm living locally. If I knew there was a court hearing, I would have been
Mr.
there.
Judge, if I could hear from you, please, as it relates to bond.
Your Honor, as it relates to bond, I did have the opportunity to speak with the petitioner prior to today's hearing. It's my understanding that there has been numerous instances of contact with the contact from respondents beginning on or around December of 2022, which I understand predates the personal protection order. This being when unwanted contact is alleged to have began. And the last instance of unwanted contact on or around February of 2025, just 5 weeks ago is what I've been informed of. I would, given both the allegations of contact and the information of continuous contact, as well as respondents' failure to appear for the prior proceeding, I believe was set for a bench trial. It does appear that there may be a concern of respondent attending future court hearings. And as such, I would argue that a GPS tether would be appropriate for both the security of the public and petitioner, as well as securing the respondent's future attendance at court proceeding.
All right.
Do
Ms.
I get a chance to speak on my own behalf?
I'm going to give you that chance. Ms. Dineski, are you incarcerated for any other matter?
Yeah, I'm incarcerated, falsely arrested, because I asked to talk to a supervisor when I was pulled over in River Rouge, and they beat me up and pulled me out of my U-Haul and beat me up and arrested me and put me in a dungeon for 3 days and then brought me
A
here.
few hours later, the prosecutor finally shows up and the hearing restarts. And yes, arraignments can often move forward without them, but the court clearly expected chaos here. Because with Lindsay, you're not just managing the case, you're managing her behavior. So they brought backup, and honestly, I get it. This is the kind of hearing where...
All right, do you
So
have
I'm fighting those charges as well. And the thing is, this PPO, since the beginning, ma'am, I have been telling you that this needs to be dismissed. I have not had my chance to put any evidence in. You unlawfully dismissed the PPO that I had against Charles Nerswick, and then you went ahead and reissued a PPO right after you dismissed the one that I had against him, which is unlawful. You dismissed the original PPO against Charles Nerswick that I had after he admitted to trying to run me over. I'm talking now. It's my turn to talk. Let me talk.
What is your bond on the felony case? You're charged with a felony right now?
I am unlawfully.
And
And I'm
what,
already getting a tether, so it's a moot point.
so what is your bond on that case?
$10,000.
Is that, a part,
And I'm going to be asking for a bond reduction.
all right, so
So
what,
I'm not even going to be getting out anytime soon anyways. But my point is that this needs to be dropped because I've never been able to show evidence. And on my,
at a $10,000 cash surety with tether?
yeah, with a 1 person or 10, whatever, I have to pay 1,000 to get out.
Okay, so it's 10,000, 10%
I guess, yeah,
with
Your
tether.
Honor,
with a tether.
Go
So
ahead.
the thing is, but my point is, I would like to speak on my own behalf about this PPO because you dismissed. You need to recuse yourself because you have violated my rights from the beginning of this case. You did not let me show evidence in my original PPO case, and you dismissed the PPO when I never had a chance to have evidence. And that man, Chuck, who kidnapped my babies from me, who has never even been found to be the biological father of these children. lawfully. The thing is that you dismissed, you said I could have a chance to talk. Please let me state my case.
Mr. Tudge would like to speak at this time. Go ahead,
It's my turn. You said I could have it, and you keep letting them speak, and you will not let me speak.
Mr. Tudge. What
It's
is
my turn to speak. So I'm going to say that this needs to be dismissed because you did not let me show evidence, and then you dismissed the PPO against a dangerous man who admitted to trying to run me over with his vehicle on his documents, and then you dismissed it and turned around and gave him a PPO against me when I was asking him to let me see Haley, who I raised for 5 years, and to get diapers for our babies, who he had abandoned for over a month, and then he kidnapped, and then you facilitated that kidnapping. So you must recuse yourself from this case because you have violated my rights numerous times, and I've asked for a quo warranto. I have asked you to show me your Article 3 oath, and you have refused. And if you're an Article 1 judge, you cannot oversee this matter.
And for anyone confused why the prosecutor is even here, this is why. The underlying case is family court, but violating a protection order can create a criminal element. A civil order can still lead to criminal consequences when it's ignored. Lindsay keeps trying to shout, "This is civil," like that ends the discussion, but it doesn't. The court is addressing the violation and the warrant. Those aren't just feelings, those are legal actions.
Ms. Dineski, your request to dismiss the matter is denied. I'll hear
Why?
from Mr. Tudge.
Why? What lawful reason do you have to continue this?
Mr. Tudge, what would you like?
What law, Judge, you need to answer me. What lawful reason do you have to continue this?
1 second. Go ahead, Mr. Tudge.
Thank you, Your Honor. As it relates to other bonds, I did have the opportunity to search. I believe the case in reference would be a 22nd District Court case. Presently, my records are not showing any arraignment having taken place. I did search the Michigan Court Case Search System and did not locate any present bond or active case involving respondents. Now, I do see that there had been issued charges for assaulting, resisting, or obstructing a police officer, which would be placed at the 22nd District Court. Also,
those were dropped. They told me that they were dropped and they let me go because they wrongfully arrested me based on a false allegation. So that I have to deal with.
I'm trying to get information from Mr. Tudge. Let him
No,
finish.
I know, but I'm letting you know what happened in that situation. Somebody had me arrested, and then they found out that the guy gave them false information, and they originally were going to charge me with that, and then they let me go that night, and they said they were dropping the charges. So for some reason, it just never got taken out of the lien system, and I didn't know that. So I do have to deal with it, but that's not my fault. That's the 22nd District's fault.
Okay, let me hear from Mr. Tudge. He's reading from the system so that I know what it is that he sees that's in the system. And so you know what's in the system. Go ahead.
I do appreciate that. Thank you.
I would also note a case out of Washtenaw County that does appear to have also been charged with 2 offenses, misdemeanor disturbing the peace and attempt misdemeanor of assaulting, resisting, or obstructing a police officer.
That's the one that got dropped.
I'm not in possession of any adjudication on the matter.
That's the one that got dropped. I'm sorry. I thought that was the 22nd Circuit.
Her dismissal demand gets denied, and she acts shocked like the judge just broke the law. But a court doesn't toss a case just because someone storms in and demands it loudly enough. You don't get a fast pass to dismissal by being combative. You follow procedure, file motions, argue them properly, and then the court rules. Screaming immediately doesn't create legal authority.
So I can't provide any further information. As it relates to respondents, what I would interpret as respondent's motion that Your Honor recuse yourself from this matter. I don't believe the requirements for recusal are met. There being no argued evidence of impropriety.
It's not really up to you to decide. You weren't there on the original case when she violated my rights and denied me a trial in the original PPO and did not let me put my evidence in. So because you violated my rights in that original PPO, you must recuse yourself. And I am demanding a new judge. I'm demanding a higher judge. I'm demanding the chief judge.
All right, Mr.
I
Tudge,
have a right to that.
Mr. Tudge,
Like, maybe outside of this, you'd be a cool lady, but you violated my rights in this court. And so I have a right to a judge who has not violated my rights.
are you asking that Ms. Dineski just be placed on tether?
Yes, Your Honor.
And I object to that. I should not have to be on a tether. I've not broken any laws. I've not harmed anybody. I'm the only one who has been harmed by this. This unlawful PPO has kept me from seeing my biological offspring for 2 years. This unlawful PPO has kept me from my babies for 2 years. They took a good mother. I was nursing my babies. I was with my babies every single day, and you guys helped a man who tried to kill me to cover up his crimes, kidnap those babies. You should be ashamed of yourself. And so because you helped kidnap my babies, I deserve a different judge. I am entitled to a different judge. You have shown misbehavior and impropriety under the canon laws of the judge's rules.
Ms. Dineski, I'm going to enter a not guilty plea on your behalf. You'll be given.
I don't consent to plea. There should not be a plea. This should be dropped.
I'm gonna give you a 10,000 personal bond. You can be released on GPS tether.
Well, then I'll just add that to the criminal charges that I'll be filing against you in federal
Then
court.
she starts talking about being pulled from the vehicle and asking for a supervisor, like that cancels the officer's lawful order. If an officer tells you to exit, that's not a debate invitation. That's a command, and refusing it is how people catch charges fast. The irony is she's quoting case law nonstop, but skips the parts that explain what police are allowed to do during a stop. You can disagree later in court. On the roadside, you
Order
comply.
that says that are you or are you not an administrative law judge? Yes or no? Why won't you answer my question? Are you an administrative law judge or are you a judicial judge?
I'll do the 10% on the 10,000.
Are you an administrative? Why will you not answer my questions? I have a right to ask you a question as a public servant.
She can.
Are you an administrative law judge, Regina Triplett? Or are you a judicial officer?
1,000 has been paid and she receives a tether, then.
Your Honor, I apologize for the interruption. However, when respondent was speaking, I noticed that it appeared that you were speaking. The audio did not come through.
Let me ask you this. So what day would you be able to do a trial, Mr. Tudge, on the allegations?
Your Honor, I did, when speaking with the petitioner, it's my understanding that there may be evidence that has yet to be sent to my office. I would believe a period of 3 weeks may be sufficient to receive the evidence. Send this
Why is he allowed to? Why is a petitioner?
I'll make that a 10,000 personal, but she has to have a GPS tether on.
So why is the petitioner allowed to submit evidence, but I've not been allowed to?
Dineski, I'm gonna release you on a 10,000 personal bond, but
What does that mean? I don't have money to pay anything.
You don't have to pay any money. You just have to show up for court for your next court date. But you will be placed on GPS tether because you cannot violate.
But I wasn't personally notified up until the point when if you guys know, remember all the hearings I did show up to? Because I was notified. When I'm notified, I show up. You cannot put a tether on me when I was not personally notified.
Your Honor, we just need a date.
Can you tell me, can I ask a question? What address was that proof of service sent to? Like, where did they send that?
They're gonna release you. Okay, you're gonna get a 10,000 personal
It's
bond.
not about that.
I know,
I
but
would like to know what address did they send that information to?
you'll be able to look at the file. You'll be able to go into the system and see what address they have for you and
But
access.
can you just tell me, isn't that on record where it was sent to?
You can go
Mr. Nestor, you'll be able to check that yourself.
But I
right.
want to know right now, because if they didn't send it to the address that I was living at, this needs to be dismissed.
Nesky, go to the records division in the basement of the city county building and you can pull all the records for the entire case. What address they served, the proof of service.
But I'm telling you, you told me it was the Elwell address. I was evicted from there in June.
No, I didn't give you an address. That's why you should go to the records division in the city county building in the basement.
But it should be, you should have the information in front of you.
The judge
gonna
has
have to go
indicated that you can check that yourself. You got a
I
list.
know, but you could also give it to me right now. Why are you refusing to give it to me when you guys have it?
When you
You
get
have
out,
to be quiet and listen.
when you get out, you can go to the city county building in the basement, but you must have tether.
But I can't get out because I have this other thing that I have to get bailed out for and I have
And
no
she's
money.
still
Well,
stuck
that-
on the article judge routine like it's a cheat code. Article this, oath that, jurisdiction challenge, fraud, same playlist, same volume, every time. The reality is nobody in that room is emotionally moved by the performance. The judge isn't confused, the prosecutor isn't intimidated, and the court isn't exposed. The only thing this accomplishes is stretching a straightforward hearing into an exhausting
Tuesday.
circus.
Your Honor,
Deal with that other case, however you deal with it. I've given you a
Okay, but I'm here and I can't get out. That's why I'm asking you what address, because I'm not gonna be able to get there.
Your Honor, may I just say this? We're going around in circles. May I just request that, we just need a date, that's all. Because
Or can I just get the discovery sent here?
Fort Williams, I was just given a date 1 second ago. I was waiting. So May 27th at 9 a.m. will be your next court date. You have that, Mr. Tudge, Ms. Fort Williams?
yes, Your Honor.
All right. So we'll see the parties back on May 17,
No,
2020,
you said 27, right?
27. I apologize.
Okay, thank you.
At 9
Sure.
a.m. Okay?
Your Honor, is
So
this
why
date-
is it okay for my rights to be violated? I want to know, why is it okay for you to violate my rights?
Ms. Dineski, may,
I want you to prove jurisdiction. Prove that you have jurisdiction over me. I'm doing a quo warranto. I'm demanding a quo warranto, and you have to prove jurisdiction over me.
Gonna get out with tether. You'll be able to access.
It's not about that. This whole entire matter is void ab initio. So you have never proved jurisdiction over me from the beginning.
Say something. Go ahead, Mr. Tudge. You got to get it out.
Your Honor, is the matter scheduled for a trial or a final pretrial?
Let's schedule it for a final pretrial.
so that's May 27th at 9 a.m., Ms. Dineski.
Yes. And
Thank you so much, Your Honor.
Tudge, you can get whatever discovery or whatever you need. Contact Ms. Abrams. And at least we'll know on that that you have everything.
So the thing is, though, is that I'm doing a jurisdictional challenge right now, and you have to prove jurisdiction before this can move forward under Michigan and federal laws.
Your Honor, she has the date.
I
so
usually
we
joke
have-
that
is
some
this
people should
concluded?
apologize
Yeah,
to trees for
Lindsay has
wasting
the date.
oxygen.
Take care and be
But with
safe.
Lindsay,
Thank you.
it's not even
Thank
a
you.
joke anymore. If she could pause for 30 seconds, let others speak, and respond point by point, she'd actually be able to make her claims cleaner. Instead, she interrupts, contradicts herself, then rewinds to fix what she just said, while still talking over everyone. That's why she keeps losing ground in real time. It's not a lack of words, it's a lack of control.